Our next lecture discusses internal investigations, top tips for managing a client crisis. Please welcome Jennifer Belveal.
Good evening, everyone. Thank you so much for allowing me to speak to you, and I apologize that I am speaking remotely tonight, but I think it's a sign of our time. So I'm glad that I can talk to you even from my own home. Tonight's presentation is on top tips for managing a client crisis, and you may be wondering why this is important to you. Not everybody practices white-collar crime or internal investigation work, but my presentation tonight is designed really to help every lawyer because, look, all of us at some point in our careers are going to get a call from a client, and we're fixers, right? So clients expect that when they call you, you're going to be able to help them in some way. And you may not be able.
There's one guy, we're all supposed to have 3 minutes, and there's one guy who probably took 6.
We are hearing some strange audio, not knowing where that is coming from. Hopefully that mic level will be taken down, and we'll get back to your presentation.
And the guys kept talking.
Do you want me to continue then?
Yes, okay. And I will just make an announcement. If everyone would please remember to mute your microphones, and we'll now get back to the lecture. Thank you.
Great. Thank you. So as I was saying, as lawyers, we're all designed to be fixers and to help our clients. And you may not be able to fix the immediate problem when a client calls you in a crisis, but you can certainly do a number of things to help them through the situation. Every single crisis for a client involving some sort of investigation is different, and yet they have a number of things in common. Oftentimes, investigations start from the authorities, right? They show up at your client's door with a search warrant at some unexpected time. A client gets wind that some executive is involved in something problematic. Regardless of how those matters start, it is an immediate crisis for the client, and now it's becoming your client. So tonight what I want to do, your problem. Tonight what I want to do is give you top 10 tips of what you can do to try to immediately address the client crisis. So that when you get the phone call, you're equipped to help the client at that moment, because that's exactly what they need is help so that things don't get worse for them and that you don't get yourself into trouble either. I am not going to pretend to be as entertaining as David Letterman, but really this is designed in the style of David Letterman, the top 10 tips, just to give you quick access to specific items that hopefully you can take this presentation, stick it in a desk drawer or in your computer somewhere. And when the client calls you and says, I got this crisis, you can pull it out and immediately have steps to take. So tip number 1 is plan in advance. And when I tell clients and other attorneys that in order to address a client crisis, you need to plan in advance. Oftentimes I get, how can we possibly plan in advance for a crisis? And you can plan in advance. And as lawyers, you can help your clients plan in advance and also make sure that the client or help ensure that the client knows to call you when the crisis arises. And one way to do that is by giving instructions. I call them front desk instructions in advance to the client. The client may say, look, I don't know if I'll ever have a crisis. Why do I need front desk instructions? Most businesses at some point in time have some sort of crisis, and they'll thank you later that you've given them front desk instructions. So oftentimes I actually type up a list of instructions to tape to the reception desk. And it would include the following items so that whoever is on duty, the first line of attack, if somebody shows up with a search warrant or a subpoena, if somebody hears about something happening that affects the client in some immediate way, they have this list. One of them is, for example, if in fact the authorities show up with a search warrant, the person who's greeting them needs to get identification from the agents and ensure who it is that shows up is someone who should be there serving a warrant, but also so that they can relay that information to you at a later time. I actually just recently, in the last 6 months, had a situation in which a client called me. It was a client I had not worked with previously and said, we have this crisis. I understand that the authorities just showed up. They told me what police department they thought it was, but they didn't get a badge number. They didn't get an officer's name. And worse yet, because of the pandemic, there wasn't a regular receptionist at the desk. So whoever happened to be milling around at the desk just let them in without getting any ID. And the officers came in and proceeded to interview a whole bunch of employees and execute a search warrant. And I was left with calling the police department that someone said they thought they recognized from their badges and asking around, trying to figure out what was going on, who from the department was there, et cetera. You're way behind the ball at that point. So you want to instruct your clients, as I said, type this up in advance. Your clients will find it very helpful to get the agent's name and the agency that they're with, if in fact a search warrant is executed on the business. You also want to instruct them to get a copy of the search warrant, and if you can, the supporting affidavit or a copy of the subpoena. Your client may not always be able to get that from the authorities, but they should certainly ask, and in many cases you can get it. The other instruction that you want to give to the front desk personnel is that they should request the authorities to wait to execute their search warrant or conduct interviews or whatever it is they're there to do until either a manager or a lawyer is called. That seems like something simple, but and oftentimes they will allow the call to be made. Seems like something simple, but if you don't instruct your client in advance that they should do that, it's not going to happen. And also, as far as planning in advance, you need to instruct your client beforehand that they should never consent to a search or give a tour, right? Be too helpful. But they also don't want to obstruct either of the authorities. So they need to stay out of the way, but they don't want to offer up information or say, hey, come on in. Sure, I'll give consent to search. It's not that in some situations you may not, you may want to give consent to search, but you certainly want to be involved in that decision making and have a deliberate decision to allow a search, as opposed to someone who appears to have authority at the front desk of a business giving consent to search. Also, as far as planning in advance, you want to make sure that the business obtains a copy of what we call the return. It's essentially an inventory of anything that's seized by the authorities. That is something that the authorities should leave behind, but sometimes they forget. So again, on your list of do's and don'ts, asking for a copy of the return is very simple, but very helpful after the fact of trying to figure out what it is that was taken. And then the last thing, again, too long to get into any detail for purposes of tonight's presentation, but you want to make sure that the employees understand their rights. You know, first and foremost, if they're approached by authorities, they should always tell the truth, but they have no obligation to speak with authorities. And the best practice for employees is always to consult with a lawyer before talking to law enforcement. Oftentimes, just because of the circumstances when the authorities show up, employees don't understand that, and they start talking without consulting with a lawyer because they think that they have to. And oftentimes, it's very important to slow that process down just to allow employees to collect their thoughts and make sure that it is in their best interest to actually be speaking to the authorities. Number 2 on my top 10 list of what to do in the case of a crying crisis. And I say this knowing that I'm presenting to all of you remotely today, is to go on site if possible. Again, may seem outdated, old school, but it truly is important to show up. Even if you think, oh, by the time I get there, the authorities may be gone, they may be done executing their search. I can't tell you how many times I have shown up and it's become crucial. Oftentimes, the authorities will allow you as a lawyer to remind employees of their rights that we just reviewed, so that you may be able to stop an impromptu interview and instead postpone it until a more reasonable time. Other times, you may offer to help the authorities. For example, I've been in this situation before where authorities have a search warrant to seize the electronic information, which in most circumstances would mean taking the computers out of the business. These days, if a client loses their computers, particularly a large number of them, that means essentially that the client's business is shut down. And yet the authorities have the right to take the computers if in fact they have a search warrant for items on that computer. They will not stop, take off files. These days, they may not even though they have the capabilities of doing so, imaging them on site, they'll just take the computers with them and your client's business may be instantly shut down. I have been successful when I'm on site actually talking to the authorities face to face, saying to them, okay, here's your search warrant, here's what you want. You're looking for a needle in a haystack. How about we help you by identifying those files that you want to copy, by identifying those laptops that contain the information that you want. And when you do that, you're of course helping your client preserve as much data as possible so they can continue to run their business. So lesson number 2, even though it says go on site if possible, really what the lesson here should be is make sure you always have a suit jacket hanging behind your office door, because you never know when you're going to get called and you might need to run out to be on site to help your client. Number 3, hire a PR firm in a crisis situation as soon as possible. We just heard from Marianne Sabo, who is experienced in this. There are lots of people who are experienced in this. Neither you nor your client are equipped to deal with client crises. My philosophy is that in most situations, it's better to say nothing. However, you have to be prepared to make a statement, because there are some times when there is press that requires a response from your client, because not saying anything at all may be a public indictment of your client. If you get a PR firm, they can help you monitor the press and social media. In client crisis situations that are truly very hot, oftentimes, I have a PR firm send us hourly updates of everything that's been posted on social media. And we are prepared to release a statement if needed, because we've already gotten the help of a PR firm who not only can help you craft that public statement, but also has the resources, the connections. They know the media outlets to go to help you release that statement if needed. I always have a statement prepared. I would say that in less than 10% of the situations, we actually release the statement, but having it prepared is essential. And also, you want to make sure, even though the PR firm is involved, that you as counsel always review and approve the comments to the media in advance, not only because you want to ensure that they're accurate, but also because I can tell you from experience that the governmental authorities monitor the media in the same way that we do. And so if there's a statement out there that they may consider taunting, or something else that the authorities are not happy with, they may fight back, and the government often has a better arsenal than we do as private practitioners. So you just want to make sure that you approve the strategy, that the language is technically correct, and that you have involvement with a PR firm. Number 4, in a crisis situation, you want to triage the situation. By that, I mean, you want to take a giant step back because the client's hair is on fire, to use the statement, I think that, or the phrase that was used in the prior presentation. And you need to be the adult in the room that helps them take a giant step back and assess things. You never want to ignore or downplay circumstances for your client, but you also don't want to inflate them. You also should help your client in triaging the situation, consider interim measures. You know, the most common interim measures that I see in my practice are putting an employee on a leave of absence, even if it's with pay. Perhaps it is diverting one segment of the business for some temporary point in time. Maybe it's locking down the client's computer system. Those types of interim measures can become crucial. And the last thing in identifying, triaging the situation is identifying the proper client contacts. This may seem silly, right? Because you may think, well, the client contact is the person I've always dealt with at the client, or maybe the client contact is the person who called me in this emergency situation. But that may not always be the case. Or it may not be the case that that's the appropriate or proper client contact. You need to think right out of the gate about excluding interested parties so that the investigation that may need to be run is seen as independent by the authorities. Sometimes that means even excluding, the CEO of the company. It may mean walling off the general counsel of the company until you can determine you've taken some steps, initial investigatory steps, to ensure that you have disinterested parties that you're interacting with and that they are not tainting your investigation. Because if you get tainted by having the wrong client contacts out of the gate, you're not going to be able to help the client. They're going to have to remove you as counsel and get separate counsel to conduct the investigation. So as quickly as possible, you need to determine, are you talking to the right people, or do you need to actually switch gears and deal with another client contact? Number 5 of my top 10 tips is to preserve documents and plan out the document review. I get that this is mundane, right? And everyone knows how to do document hold notices and do document reviews. There's all sorts of software, etc. We all do it in our practice, whether it's in the white collar space or in the civil space. And in the investigation space, I can tell you, however, that documents are usually the most important element, and yet they're often overlooked. I have investigations on a large scale in the automotive industry, for example, that I'm thinking of, that literally have millions of documents. There is no way that I personally can review all those documents, and there's no way even the folks that are working with me closely, the lieutenants, can review all those documents. But we can make the document reviewers a resource. So thinking really early on about what the protocol should be for the document review and educating those reviewers to make them reliable resources is important at the outset. Of course, the document hold notices have to go out right away as well, and you have to revisit often the need for document hold notices going to additional document custodians. But really thinking about upfront and planning what you're going to do to collect and review documents is crucial. Number 6 on the top 10 list, Scope out the investigation that's needed in order to respond to the client crisis. Be deliberate so that the matter does not spin out of control, and document it by actually writing out your investigation plan. This will allow your client to have input, will allow your client to have expectations around what the work is that's going to be done, and you'll know when you're finished, right? I hear a lot of times lawyers talk about, well, I'm conducting an investigation into something, and yet they don't have an end point. You know, they're just going to keep investigating forever. Let me tell you, clients get tired of that, and they're not going to want to continue to pay you without knowing what the end game is. The scope often changes, and you have to reevaluate it as needed. So the client expectations should be set around the fact that your investigation plan is not set in stone, but will be reevaluated. However, having a plan in writing and being able to refer back to it is really important. Number 7, I say pick your team carefully. What does that mean? Think about it at the outset, right? There's lots of thorny ethics, representation issues, conflict issues, whether or not you can represent members of management, those same people who have sent you business in the past, or may have been the one who picked up the phone and called you or told someone to call you. Think about whether or not you can represent them or other key employees. Oftentimes you cannot, in which case the company is going to have to make a decision about whether or not to get additional counsel at the company's expense for those other employees. But you don't want to conflict yourself out of the future investigation or the ongoing investigation because at the outset you started having privileged independent conversations with members of management and employees. You need to make clear at the outset that you represent the company and not the employees, so that later the employees can't say, well, I thought you were my personal counsel. In the same way, when you're picking your team and who it is that you're going to represent, think about joint defense agreements carefully. As we all know in Michigan, joint defense agreements do not have to be written on paper. So you can, in fact, make oral joint defense agreements, but think very carefully about whether or not it makes sense to enter in joint defense agreements with others involved in the matter. Oftentimes it does, but if you represent the company, think about the need to conduct interviews of employees and the need perhaps to turn over information to the government or to utilize that information. And if you do so under the cloak of a joint defense agreement, you won't be able to use that information externally. And lastly, beware of preserving privilege with consultants. This kind of ties into number 8, where I said, don't be afraid to call the experts. Oftentimes you're going to need an accountant, a forensic accountant, or a technical consultant. But be careful about preserving privilege to the extent that you can by retaining them yourself rather than having the client do so directly. And also, when we're talking about experts, know your limits, right? Witness interviews are not the same as depositions. I tell my colleagues this all the time. If you don't know what an upjohn warning is and you're not so well versed in upjohn warnings that you can give them in your sleep, you probably shouldn't be conducting a witness interview on your own, because it could become extremely problematic for the company at a later date. By the same token, search warrants and government subpoenas are much different than civil discovery, right? In civil discovery, you blow a deadline or get close to a deadline, you can get an extension. It's not a big deal. Oftentimes there are lines drawn in civil discovery that the parties fight about later, about what's appropriate for production and what's not. You have much less control in a situation involving a government subpoena or a search warrant if you start trying to control the situation, you yourself, or even your client, may be charged with obstruction. So again, just know your limits and make sure you're consulting with appropriate experts who know these systems and processes. Number 9, I say communicate with the authorities early and often. You want to establish a rapport with the authorities. As I noted earlier in one of my recent situations, why was I calling around the police department trying to figure out who came out there? Because I wanted them to know that the client had counsel and that they could come to me. That's extremely helpful, as you can learn information from your sources. And if you become a reliable source of information, even for things very trivial to the government, I'm not suggesting that at the outset you want to share everything, but if you become a reliable source of information, you will get information yourself and the government will find you as trustworthy. So communicate with the authorities early and often so that you can establish a theme, right? It's like a long-running trial when you're involved in an investigation. At trial, we all know, as litigators, you have to have a theme and you go through that theme over and over again. It's very similar with an investigation. And my final top 10 tip for how to help a client in a crisis situation is to follow the facts. Be open-minded. You know, a client may tell you something at the outset, and yes, we all want to believe our clients, but maybe the client didn't have all the information. Follow the facts. Don't be afraid, however, to push back against the government. You know, sometimes people think automatically that the government is always right. And in fact, that's not always the case. In some situations, you want to be selective, but you need to push back against the government. Don't assume they're correct. One thing I have noticed over my career is that oftentimes, particularly lawyers who used to be in government, right? So they used to be a prosecutor, etc. They're not as willing to assume that there are appropriate times to push back. Instead, they're assuming that the government's always right. They must be right. And that's not the case. So follow the facts, be open-minded, and don't assume that the government's always right. So with there, I am going to pause and see if there are any questions, either on the chat virtually or from inside the Detroit Club.
Jennifer, hi, this is Aida. A question about experts. When would you recommend a company to select also white-collar attorneys? Sometimes in investigations, people think that they can go to a criminal defense attorney who does not have experience with white-collar. And this happens actually often. So at what point do you do that? And also, if you are a general counsel, so that's the second question. If you're a general counsel to a company that is facing an investigation, naturally you cannot provide a list of white-collar attorneys. The CEO has to do that. So again, timing is important. When do you suggest in both questions to select those white collar? Do you as an attorney, do you interview them, or do you let the company interview the white collar attorneys? Thank you.
Yeah, so it's a great question. Look, I think that other lawyers, whether they're in-house or outside counsel, should be familiar with who their resources are, right? We all know who we refer a real estate deal to or a divorce lawyer to, or a divorce case to, if we don't do that kind of work. And so having availability of several options, because different clients may have different fits with different counsel, to have those at their fingertips. With regard to in-house clients, companies that is, when they put together their front desk instructions, as I call them, that's usually a good time to consult with white-collar lawyers, to talk to them about how do I put together my front desk instructions, and in that process of working with them and talking to them, it's kind of an interview, right? You get to understand their style. Having counsel that understands a company and their style, their risk tolerance in advance is very important. But, it's a great question. The sooner we can get involved, I think the better the outcomes. Sometimes there's not always time to interview white collar lawyers when there's a crisis, but you absolutely should have some interaction with them before you just hire them to start conducting an investigation. That's for certain. Any other questions? Hearing none, I think I'm exactly at the end of my time for this evening. So thank you very much, all of you, and I look forward to seeing you in person soon.